Good afternoon. We are continuing our chapter on invasion of privacy. Last time we talked about appropriation and intrusion, two branches or two torts under privacy. Today we're going to talk about the publication of embarrassing private facts and false light. So let's dive in. The first tort that we're going to talk about today, tort 3 in your notes, the publication of embarrassing private facts. What are the elements? It has to be a public disclosure of embarrassing private facts, and it needs to be not newsworthy. And the standard, the default standard in these cases are the information was highly offensive to a reasonable person. Now, this may sound kind of similar to libel, and there are some similarities, but there are two significant differences. One, the information being disclosed is true, not false, as in a libel case. So truth is not a defense. The other significant difference is that it's not harmful to your reputation, but it's considered highly offensive to a reasonable person. That's the standard. So, what are we talking about? What kind of example? One example would be if someone has terminal cancer and they want to keep it private, they just tell their close friends and family, and then a reporter finds it out in whatever way and they write the story, or somebody posts something on social media. And this was something that the individual did not want to be made public. And so this is an invasion of their privacy. So it must be truly private facts. So in this example, if someone has cancer and they don't want to, share it, and they have only shared it to their family and a couple of close friends, then that wouldn't disqualify them from suing for the publication of embarrassing private facts. On the flip side, if that individual had told their family, told their church group, told their company, they sent out an email to everybody in their company saying, I have cancer and I'm not going to be around, and things like that, then that wide dissemination might disqualify them from filing suit against the publication, or the social media post, the person who posted it. Privilege often applies in situations like this. So the absolute privilege for legislatures that we talked about under libel law, the qualified privilege that applies to reporters who are reporting on legislative proceedings, official government proceedings, those could also be effective defenses. Let's look at a case that fleshes this out, and maybe this will help it make more sense. Cox Broadcasting versus Cohn. What's the background? Martin Cohn was the father of a 17-year-old girl who was raped and killed in Georgia. After obtaining information from the public record, from court documents, a television station, WSB in Georgia, broadcast the name of Cohn's daughter in connection with the incident. This violated a Georgia shield law that prevented members of the media from publicizing names or identities of rape victims. And to be honest, Georgia was not the only one. There were a number of states across the country that had similar shield laws for the names of rape victims. Martin Cohn filed suit against Cox Broadcasting, the parent company of the station, on two counts: one, for violating this Georgia shield law, and second, for violating his common law right to privacy. The trial court granted summary judgment for Cohn, um, although they rejected Cox's First Amendment defense that the First Amendment protected them from this claim. Cox Broadcasting appealed. It went to the Georgia Supreme Court, Now, Georgia's Supreme Court dismissed Cohn's claim under the Georgia Shield Law because they ruled that he didn't have standing to bring a civil suit against Cox Broadcasting for violating a Georgia criminal law. However, they did allow Cohn's common law privacy claim to stand. Cox Broadcasting appealed, and the Georgia Supreme Court was still, working on their ruling, but SCOTUS granted cert. The Supreme Court ruled that the Georgia Shield Law was unconstitutional. They held that the interest of privacy fades in cases where controversial information already appeared in the public record. And this creates what we now know as the public record privilege for reporters. And so there is a defense for reporters that if they gain information from the public record, then it's not considered an invasion of privacy. So this may seem very callous because obviously Georgia meant well. They were just trying to protect the names of rape victims. There are a number of states that were doing this. But the short version is states were encouraged to think differently. And instead of placing a burden on the press to not report information that they gain, and especially information in this case that they gained legally, instead, states were encouraged to maybe consider passing a law that sealed the names of rape victims in cases like this so that the press would not gain access to it. And so it's just the tension. This is that preferred position balancing theory in action. That, yes, there is a compelling government interest to protect the privacy of rape victims. But when you weigh it against the freedom of press, the freedom of press was given preference, and another alternative need to be sought. So what do we need to understand about the publication of embarrassing private facts? First of all, you need to understand that occurrences that happen in public places are not private. And so maybe you do something that is embarrassing, but you did it in public, then if someone outs you, if you make a fool of yourself in public and someone puts it on Facebook Live and everybody sees it, then it's not going to be something that you can file suit over. What we learned from Cox Broadcasting versus Cohn is that information that's in a public record is not private. Newsworthiness is a valid defense. There is a First Amendment protection for newsworthy information that's in the public interest. That legitimate public interest is the legal terminology for the current standard in determining whether the publication of embarrassing private facts is protected by the First Amendment or not. But when you are publishing something, when you have taken a photo, when you have shot a video, you do need to avoid what would be called humiliation for its own sake. And there are situations where you might think that this is newsworthy, but since it is so humiliating, the court might actually rule against you. And something to keep in mind is that time does not make a public item private again. And your chapter covers a couple of good cases where somebody did something in the past, they have tried to move on from it, but 25 years later, somebody brings it back up. Just because most people didn't know about it doesn't mean that it was private. And so time does not make a public item private again. So that is the publication of embarrassing private facts. Now let's move on to our fourth tort, false light. False light is the closest to defamation, to libel, because it is the false representation of an individual disseminated to the general public. So it's false, it's published, it's identifiable. All this terminology sounds very similar to what we covered last chapter. But the difference is, instead of damaging your reputation, it's false information that would be considered highly offensive to a reasonable person. And in this, a difference between libel law and false light is you do not have to prove harm, because it's not harmful to your reputation, so you don't have to prove harm. There are three categories of false light: distortion or contextual false light, embellishment, and fictionalization. Let's talk a little about each of these. Distortion would be like the arrangement of information or materials or photographs that give a false impression. Embellishment would be the addition of false material to a story that places someone in the false light. So some of the information is accurate, but you embellish, you add information. And fictionalization is references to real people in fictitious articles, or the inclusion of works of fiction that represent real people. In false light cases, the fault standards for libel apply. So, actual malice for public officials and public persons, negligence for private persons. Opinions are not liable for a false light case, just as in a libel case. Retractions can help mitigate damages in false light cases, much in the way that they do in libel cases. And you do need to understand that some states do not recognize the false light tort. If it's not libelous, then they don't recognize false information that's just highly offensive. So let's look at a case that fleshes this out. And this is the only Supreme Court case to ever rule on false light. And it's relatively old, and we'll look at it. It starts in 1952, when there were three escaped convicts were looking for a place to hide, and so they take James Hill, his wife, and their 5 children hostage in their White Marsh, Pennsylvania home. After 19 hours being held hostage, the family was released unharmed. The convicts were later apprehended in a violent clash and with police, during which 2 of them were killed. It was big news. This was a big news piece. And so in 1953, a year later, Joseph Hayes published a novel based on the Hill family's ordeal. Now, the novel really wasn't a problem. The novel was subsequently made into a play. And again, the play in and of itself was not the problem. The problem came when Life magazine, owned by Time Incorporated, printed an article about the play, and they pointed out that the occurrences that happened in the play were the same things that happened to the Hill family. And they went so far as to, in kind of this example of embellishment and fictionalization, they made connections that the play did not make. And so when this happened in the play, this was like what happened to James Hill. But they also took the actors from the play and they took them to the White Marsh home. The Hill family didn't live there anymore, but they took them there and had them kind of reenact parts of the play in the home, further making this connection. And this, the Time was sued. The Hill family filed suit, alleging that it deliberately misrepresented his story. At trial, the jury awarded the Hills $50,000 in actual damages and $25,000 in punitive damages. Time appealed, and on appeal, the Appellate Division of the New York Supreme Court remanded for a new trial where a reduced adverse ruling was imposed on life. So they still ruled against life, but the damage was reduced. Now, Time tried to appeal to the New York Court of Appeals again, but while they were doing that, the United States Supreme Court granted cert. In a 6-3 opinion, SCOTUS set aside the appellate ruling against Time because the lower court failed to instruct the jury that Time's liability was contingent upon a showing of actual malice. What does that mean? That means that for the Hill family to win, they had to prove actual malice, that Time knew it was false, or that they showed reckless disregard for falsity or truth. The court explained that absence of finding of such actual malice on the part of the publisher, press statements are protected under the First Amendment even if they are otherwise false or inaccurate. The court remanded for retrial under these new jury instructions, and the Hill family loses because they cannot prove actual malice, they could just prove negligence. So, what's significant about this case? Well, it is the first and only false light case ruled on by the Supreme Court. Also, interestingly, it was horribly timed because this was ruled on in 1971, and it was in between Metro Media versus Rosenblum. And if you remember, the Rosenblum case stated that all stories of public interest were protected and you had to prove actual malice to win a libel case. But then a couple of years later, the Gertz versus Robert Welsh case, the Supreme Court kind of reversed themselves where they ruled that private persons must only prove negligence. And so in this situation, the Hill family really probably should have been able to win their case, but they did it at a time when the Supreme Court was hardcore on proving actual malice, and it was only be a couple of years later when they backed off of that. What is our walk away from this? We just need to understand that false light cases, if you're in a state that recognizes false light, you have to follow the false standards of libel. Okay, so we've covered embarrassing facts and we've covered false light. So there are just some general privacy guidelines that we can walk away from. In summary, you need to understand that scenes that are open to public view can be photographed, and information that's in public records may be reported on without consent. Private information about an individual, once you have it, may always be published or broadcast if there's a legitimate news purpose, that legitimate public interest exists. In areas specifically intended for privacy, like private homes, motel rooms, bathrooms, you may not secretly snoop, tape record, photograph, video, even if a newsworthy motive exists. And then a couple of other concepts. Inappropriation, written consent. In most situations, you could record it, like if you're in video, but clear recorded consent must be obtained before using a person's name or picture in a commercial message. Written consent is definitely preferable. And people should not be represented in a misleading and highly objectionable context without their consent. So these are just general guidelines that should help you go through this. So, you can photograph in the public, but you don't need to use artificial means like zoom lenses, drones, recording equipment that captures people in a place where a reasonable expectation of privacy exists. And you also need to be very, careful about how you depict someone, especially a, private individual. You need to make sure that it's not misleading, and you need to make sure that it is not highly objectionable. All right, so we're done with privacy. Now you need to move on. We're going to move on to copyright. And there's going to be the next class period's presentation on copyright is also available on Moodle for you to watch on Thursday.